The red notice was fastened to my stallion gate with 4 steel screws on March 27, 2025. Laura Pike stood on the public side of the fence, while a livestock broker waited beside an empty 2-horse trailer. Her voice stayed level. She opened a red compliance binder and told me the Juniper Ridge Owners Association would assess a $2,500 fine every day a breeding stallion remained housed, exercised, or bred within what she called Parcel 7B of East Meadow. The printed notice gave me 72 hours to remove all 8 from that parcel. Laura went further. She said, temporary pens, elsewhere, on High Mesa would not satisfy the board, and that the daily charges would continue unless I produced contracts listing the stallions for sale. Orion, my aunt's dark bay, struck one hoof against the stall mat behind me. Laura glanced toward the sound and called him an unacceptable safety exposure to 86 families. I left the notice in place. I photographed the screws, the gate, the trailer, and the tracks its tires had left in the roadside dust. Then, I read the packet. From the first page to the last, the emergency equine fine schedule was dated 12 days before the meeting that supposedly adopted it. A second attachment claimed my East Meadow was already inside the HOA. Its legal description used a name I had seen only once, Parcel 7B. I wrote both details in the Bound Ranch incident log. Laura mistook that for hesitation. Mr. Hale, delay will only make this more expensive, she said. Then the dates should be right, I answered. I closed the gate, left the notice exactly where it was, and called a veterinarian before I called a lawyer. If someone intended to turn 8 living animals into leverage, I wanted their condition documented before the first accusation could change shape. My name is Evan Hale. I was 62 when I inherited High Mesa in March 2025. High Mesa was not a decorative ranch with a lodge, a few polite horses, and a sign made for photographs. It covered 6,800 acres of high country pasture in Redstone County, Colorado. Osage Flats rose toward blue-gray mesas on the west. Cottonwoods followed a narrow creek south of the Stone Ranch house. The old red stallion barn stood in East Meadow, far enough from Juniper Ridge that ordinary barn sounds reached the nearest homes, only when the wind came down from the north. The size of the ranch made Laura's deadline sound easy until a person looked at the land. High Mesa had thousands of grazing acres, but East Meadow held the ranch's only double-fenced stallion complex. Breeding stocks, veterinary handling chute, separate water system, and loading lane. The northern flats were seasonal cattle and mare pasture. The western ground climbed through broken mesa and open range. The hay fields beside the creek had ordinary livestock fence, not the separated lanes and reinforced paddocks required for breeding males. I could not solve a claimed safety problem by turning 8 stallions onto open acreage. Moving them safely off East Meadow required inspected off-site stalls, individual transport plans, handlers, and time. It was not a responsible 72-hour cure, and temporary panels on the North Flats would have created the very risk Laura claimed to fear. My Aunt Ruth Hale had run that land for 43 years, raising working quarter horses and preserving 3 bloodlines. During childhood summers, she taught me to clean a wound, check a trough, and wait until a frightened horse chose to step forward. To her, patience was simply how a person worked without causing new damage. Ruth died at 81, shortly before I retired from 31 years of inspecting agricultural operations for insurers. I was no lawyer, but the work taught me the value of a baseline. Photograph damage before repair, document an animal before accusations change, and preserve every page and date. During my first week at High Mesa, I formalized the Bound Ranch incident log for pasture conditions, repairs, animal care, and every visiting vehicle. I photographed each stallion and had Dr. Samuel Ortiz complete health and temperament examinations. One horse had an old tendon scar, Orion disliked plastic tarps, and another became restless when isolated. None had a history of attacking a handler, breaking a fence, or leaving the property. The 8 stallions were not 8 copies of one valuable animal. They represented decades of choices. Orion carried the last direct line from Ruth's first ranch sire. Copper Ridge passed a calm temperament into ranch horses used by older riders. 2 younger stallions had not yet entered breeding service. Selling them quickly would scatter the program before I had even decided how to continue it. I was not opposed to change. I had already planned to reduce the herd gradually, repair the North Mare barn, and hire an experienced breeding manager. But there is a difference between making a responsible decision and obeying a 72-hour demand from people who may not have authority over you. Juniper Ridge occupied the former eastern edge of the Hale property. Ruth had sold a development company a narrow block of dry ground many years earlier. That company built 86 homes, a tan stucco clubhouse, and a landscaped entrance that faced the county highway. The subdivision had its own recorded declaration which functioned like a private rulebook for the lots inside it. The arrangement was not entirely separate. High Mesa and Juniper Ridge shared the first mile of an access road. A recorded maintenance agreement required the ranch to pay a fair portion of grading and snow removal. The ranch also held an emergency right to move livestock trailers through a secondary gate if the creek crossing failed. Those shared rights gave Laura's claim a surface of credibility. The ranch deed referred to the road agreement. Several old maps showed High Mesa and Juniper Ridge on the same sheet. A person reading only the references could believe the ranch had joined the subdivision in some limited way. That uncertainty kept me from tearing down the notice and declaring the matter finished. After Laura returned to her vehicle, I asked the embarrassed broker whether anyone had hired him to take possession of a horse. He said he had only been asked to discuss market options and confirmed that nobody had told him. I agreed to sell. I recorded his name and answer. He drove away without opening the trailer. Dr. Ortiz arrived that afternoon. He examined the stallions, reviewed the handling logs Ruth had kept, checked the fences, and photographed the double gate system between the barn and East Meadow. His written report described a professionally managed breeding facility with no immediate animal control hazard. I scanned it, saved the original, and gave a copy to Martin Shaw, a land use attorney in the county seat. Martin had represented farm owners in covenant and access disputes for more than 2 decades. His office was above a pharmacy, with plain gray carpet and file boxes arranged by year. He read Laura's packet without speaking. When he reached the fine schedule, he placed a yellow note beside the adoption date. When he reached the annexation attachment, he placed a second note beside parcel 7B. "Do you recognize this signature?" he asked. The page carried Ruth's name in blue ink. The long downward stroke on the M looked like hers. So did the small break before the final R. "It may be genuine," I said. Martin nodded. "That is the useful answer. We authenticate before we accuse." Then he returned to the first page. "Colorado did not permit daily covenant fines," he said. "Even a claimed public safety violation required written notice, 72 hours to cure, a follow-up inspection, and fines no more often than every other day. Laura's schedule was defective before we even reached the land question. The notice had supplied a deadline, but it declared that daily charges would begin automatically and promised no association inspection after the cure period. Laura's roadside photographs were not an inspection, and the word dangerous could not excuse the board from the required sequence. The document was titled Conditional Consent to Future Annexation. It appeared to have been signed in 1999. In plain language, Ruth had agreed that some described land could later be added to the Juniper Ridge Declaration if 2 things happened. The ranch lender had to release that land from restrictions in its loan documents, and a supplemental declaration had to be recorded at the same time. The HOA packet contained no lender release. It included a stamped copy of the conditional consent, a 3-page legal description labeled Exhibit C, and a color map that shaded most of East Meadow. The last page referred to East Meadow Parcel 7B. "Was the supplemental declaration recorded?" I asked. "I do not know," Martin said. "The county index will tell us what it contains. It will not decide what the documents mean." He gave me a short list. We needed a complete title search, the original subdivision declaration, and every recorded amendment, the road agreement, the ranch loan files from 1999, board minutes, fine schedules, and the metadata or paper source for Laura's combined scan. He also wanted a licensed surveyor to compare the legal descriptions on the ground. "Do we respond to the 72-hour deadline?" I asked. "Yes, we acknowledge receipt. We deny consent to entry, sale, or handling of any horse. We request the authority they rely on. We do not argue the entire case in a letter." That evening, I photographed the notice and screw heads beside a ruler, protected the packet with a clear weather sleeve, and logged the condition of every latch. The next morning, Martin sent a restrained 4-paragraph response by certified mail and email. It avoided threats and accusations of corruption. Instead, it requested the recorded instruments that allegedly subjected High Mesa to the declaration, the properly adopted fine schedule, the meeting notice and minutes, and the rule authorizing an order to sell privately owned livestock. Laura answered before lunch. Her email said the association's jurisdiction had been settled for years. It said Ruth's signature bound every successor. It said my refusal to remove the stallions forced the board to act for community safety. At the bottom, Laura copied the HOA's management company and its attorney. No recording number accompanied the email. I printed the email, noted the time received, and filed it behind the original packet. Then I went out to feed the horses. Orion lowered his head over the stall door while I measured grain, unaware that a daily fine had begun to follow his name. 2 county vehicles arrived 3 days later, after Laura reported aggressive animals, inadequate containment, and unpermitted waste storage. Zoning and animal control officers reviewed my agricultural records. Veterinary report, paddock map, and manure plan. They chose the gates to inspect, watched Orion accept a halter, checked the double fencing and water, and measured the barn's distance from the subdivision. They found only a cracked trailer reflector and a drainage grate that needed cleaning. I corrected both before they left. Their written findings said the ranch use was lawful. The facility predated the neighboring homes. The stallions were contained and cared for, and no county action was recommended. The HOA attorney replied that public compliance left private covenant enforcement unresolved. On that narrow point, he was right. A county finding could neither cancel a valid private restriction nor create one. Laura had lost the support of public enforcement, not the private clock she claimed to control. The first fine ledger arrived in a white envelope from the management company. It counted March 27, the day the notice went up, as the first violation, and added another charge for every calendar day after that, even though its own 72-hour deadline ran through March 30. No association. Inspector returned after the cure period. A hearing notice said I could appear before the board, present evidence, and request that the assessment be withdrawn. Martin advised me to attend. If we refuse their process, they will describe that as an admission or a waiver, he said. We make the record. We do not expect the board to become neutral. The hearing took place in the Juniper Ridge clubhouse. I sat at a folding table with Martin. Laura sat at the center of a raised board table beneath a decorative mountain photograph. 4 directors were present. The management representative operated a laptop at the end. Laura opened by saying the meeting concerned equine safety, not ownership. Martin asked whether the board had determined that High Mesa was subject to the declaration. Laura said the 1999 consent settled that question. Martin asked for the recording number of the supplemental declaration. The HOA attorney interrupted and said recordation was not the only path to enforcement when a successor had actual notice. That was the first serious version of their position. They were not saying a missing document would appear if we waited. They were saying Ruth's signature, the shared road agreement, and my knowledge of the subdivision together allowed the HOA to enforce the consent. Martin placed the county findings and veterinary report into the hearing record. He also objected that the daily ledger violated Colorado's fine frequency rule, that the HOA had performed no required post-cure inspection, and that the schedule appeared to predate any board vote. Laura accepted the documents without changing expression. Then she displayed photographs of the stallion barn taken from the public side of East Meadow. None showed a loose horse or damaged fence. One showed Orion running beside the inner rail during morning exercise. A breeding stallion is not an ordinary household animal, Laura said. The board cannot wait for an escape before addressing foreseeable risk. I told the board how the double gate system worked. I described the separate paddocks, handler requirements, and emergency plan. I made no impossible promise that a horse could never cause harm. The existing evidence showed controlled risk, not a present nuisance. One director asked whether temporary relocation could protect the horses while the jurisdiction question was reviewed. Martin offered a practical standstill, pause new breeding, inspect 2 licensed equine facilities, and move the stallions off-site in stages over 14 days, provided the fines stopped and the move conceded no HOA authority. I also agreed to an independent safety inspection and reasonable sound monitoring. Laura rejected the proposal. She said horses that might return would not create the permanent animal-free buffer the board required. Only sale contracts for all 8 would prove compliance. That answer put the broker at my gate in a different light. The emergency was not that the stallions could not be contained for 14 days. It was that I still owned them and could bring them home. Laura closed the hearing after 41 minutes. She said a written decision would follow. It arrived the next morning. The board upheld every daily fine and ordered me to submit sale contracts for the 8 stallions as proof of compliance. The decision identified no post-cure inspection and ignored Martin's objection to the daily schedule. I noted that the decision quoted the emergency equine fine schedule, while including no minutes showing when that schedule had been adopted. I placed it behind a new tab marked Private Hearing. The pressure moved beyond paper 2 days later. A mare owner from another county called the ranch office. She had reserved a breeding slot with Orion months before Ruth became ill. Someone had sent her the HOA's Community Safety Bulletin, which described High Mesa as an unlicensed hazardous breeding facility under active enforcement. Her question carried no accusation. She asked whether Orion might be sold before her mare arrived. I told her the horse remained at High Mesa and the county had found no violation. She paused the booking until the dispute was resolved. A second client did the same that week. The ranch kept operating, but the cancellations changed the nature of the damage. Laura's notice was no longer only a threat of future fines. Her description of the ranch had begun to interfere with the season, already scheduled. I saved both emails and kept the clients out of the dispute. Martin sent the HOA attorney a demand to correct the bulletin and preserve its distribution list. He answered that the statement accurately described pending association enforcement. By then, licensed surveyor Gabriel Soto had begun fieldwork along East Meadow. Gabriel was 54, patient and economical with words. He set his equipment on the ranch side, located the recorded monuments, and compared the subdivision plat with the ranch deed. I walked with him, while keeping my preferred result to myself. A surveyor locates described lines. He leaves covenant interpretation to the lawyers and the court. The stallion barn sat entirely within High Mesa. The nearest paddock fence stood hundreds of feet from the Juniper Ridge boundary. No subdivision structure crossed onto the ranch, and no ranch structure crossed into the subdivision. The physical boundary was not uncertain. The paper history was less clean. Gabriel enlarged the HOA's Exhibit C on a field tablet. He traced the meets and bounds description and stopped at the caption. East Meadow Parcel 7B, he read. Do you know when that parcel was created? No. Neither do I yet. But this description uses a survey control point that is not on the original subdivision plat. Gabriel refused to guess beyond that. He requested the county survey index, all boundary line adjustments involving the ranch, and the surveyor's original job records if they still existed. I wrote the question in the incident log beneath my first entry from the gate. Martin's title examiner found the 1998 Juniper Ridge Declaration and 6 amendments, none annexed High Mesa. A separate instrument recorded in 2001 transferred the developer's limited right to complete any already approved East Meadow annexation to Juniper Ridge, acting as successor declarant. The assignment gave the HOA a serious surface argument, but its wording preserved every existing owner and lender condition and left the original December 31, 2002 deadline unchanged. Some of their claimed authority is real, Martin said, but an assignment transfers only the right the developer still possessed. It cannot enlarge that right, erase Ruth's lender release condition, or restart an expired clock. The road maintenance agreement appeared exactly as my deed described it. It divided costs and granted emergency passage, while creating neither HOA membership nor authority over ranch animals. The county clerk and recorder's office provided a certified index report showing no supplemental declaration against the High Mesa deed before I inherited it. The office offered no declaration of victory. It maintained records rather than adjudicating private rights, and the report simply identified what the index contained. The 1999 consent remained the difficult part. Ruth's signature looked authentic. The document stated that its obligations would bind successors once its conditions were satisfied. The HOA attorney argued those conditions had been fulfilled through conduct, even if a clerk never indexed the final instrument. Martin considered that argument weak, but not imaginary. Courts can treat notice, reliance, and accepted benefits as important facts. Juniper Ridge had maintained the shared road for years. High Mesa had paid its allocated share. Laura would try to describe those payments as acceptance of a larger community arrangement. The road agreement explains every payment, Martin said, but I want the original loan file. If the consent required a lender release, we need to know whether the lender gave one. Ruth's lender had been Mesa Community Bank, later absorbed by a regional company, whose archived paper files were stored out of county. I requested the file with the probate order. Retrieval would take weeks. The consent named loan officer Thomas Bell, now 66 and retired. He remembered Ruth but declined to reconstruct a lender release from memory. We agreed to speak with Martin after the archive arrived, and added that in 1999 he had volunteered as Juniper Ridge's treasurer. That connection might supply knowledge or invite a challenge to his neutrality. So I recorded his words and ended the call. At the end of that month, the management company referred the accumulating fine balance to a collection firm. The letter warned that the association could pursue a lien if the debt remained unpaid. Martin checked every minute produced so far. None contained the recorded majority vote Colorado required. before an account could be sent to a collection agency or attorney. His dispute letter identified 3 separate defects without conceding that I was an association owner. The charges ran daily. No post-cure inspection supported them, and the account had been referred before a recorded board vote. He demanded a complete owner ledger, the adoption records, and the vote authorizing collection. The collection firm marked the balance disputed, but the management company left the referral active. I continued the ranch routine and recorded quiet days as carefully as troubled ones. Those entries showed that no horse escaped, no fence failed, and no confrontation occurred while the fines rose. The HOA resisted Martin's records demand for 9 days. Its attorney said High Mesa could not claim member inspection rights while denying membership. Martin answered that the association could not assess me as an owner and then treat me as a stranger when I asked how the assessment was authorized. The board produced a digital folder soon afterward. It contained years of minutes, a fine ledger, insurance correspondence, and a copy of the 1999 consent, the original paper file. Lender release, and source record for the attachment of Exhibit C were all missing. The meeting records changed the fine issue. Laura had circulated the emergency equine fine schedule to the management company before any board vote. Her email called it effective immediately. 12 days later, the board discussed horse restrictions during an executive session, a closed portion of the meeting generally used for confidential legal or personnel matters. The minutes recorded only a motion to seek legal advice, with no adoption of the schedule and no vote to refer my account for collection. At the next open meeting, the board voted to confirm ongoing enforcement. Laura would later call that confirmation a ratification. Martin called it evidence that the schedule had been used before the board acted. The motion named neither my account nor a collection firm and recorded no majority decision to make a referral. That evidence was useful but left the larger question unanswered. If High Mesa was never under the declaration, the procedure was irrelevant. If a court found the ranch bound in some way, the HOA would argue that later board action cured an earlier defect. Another folder contained monthly reports from the management company. Most entries concerned landscaping, road grading, and clubhouse repairs. One report mentioned a proposed secondary exit through East Meadow. A second referred to animal use compatibility. Neither explained why those phrases had suddenly become priorities. Martin asked for the attachments listed in the reports. The HOA attorney objected that development discussions were confidential. Martin narrowed the request to documents the board had relied on when describing my stallions as a community risk. The missing attachment arrived 3 days later. It was an unsigned term sheet from Mesa Crest Resorts. The company proposed funding a paved secondary exit, a public-facing trailhead, and new landscaping at the Juniper Ridge entrance. In return, the association would support a future application involving land near East Meadow. One condition appeared twice. The meadow beside the subdivision had to become a permanent animal-free buffer. The document granted Juniper Ridge no rights over my land and proved neither bribery nor crime. It explained Laura's urgency. A secondary exit and trailhead would make the eastern homes easier to market, and Laura could present both as lasting achievements. The safely managed stallion barn made the promised buffer impossible. Martin placed the term sheet beside the safety bulletin. The horses were selected without any triggering incident, he said. Someone promised a land condition beyond the board's control. Ruth's bloodlines had become an obstacle on a planning sheet. That evening, I watched the separated stallions graze beneath the Juniper Ridge roofs. Nothing in East Meadow looked like an emergency. I wrote one sentence in the incident log. Motive cannot create authority. The term sheet explained conduct. We still had to prove what governed the land. Gabriel's preliminary survey report arrived with a clean boundary overlay. It confirmed that the HOA's shaded map extended across High Mesa without following any line in the 1998 declaration. The purported Exhibit C followed a real line, but Gabriel had yet to establish when that line was created. The county's older survey books were being digitized, and the relevant index entry referred to a box held off-site. I can tell you where the description runs, he said. I cannot yet tell you whether it existed in 1999. Martin added Gabriel's report to the file and scheduled a settlement conference. He wanted to test the HOA's position before filing suit. Litigation could protect the ranch, but even an early injunction required evidence, pleadings, notice, and a judge's decision. It was not a switch we could turn overnight. The conference took place in Martin's office. Laura attended with the HOA attorney, and a representative from the management company. Laura placed the combined consent and Exhibit C at the center of the table. Her attorney acknowledged that no supplemental declaration had been found in the county index. He relied on the 2001 recorded assignment and argued that Juniper Ridge had inherited the developer's annexation right. Ruth had signed a binding consent, and the ranch had accepted shared road services, while East Meadow was treated as future association land. He said a court could enforce that history, even if the recording sequence was incomplete. Martin asked for the lender release and the source showing when Exhibit C had joined Ruth's signature page. The attorney argued that an absent copy failed to prove refusal. The management representative said, "The combined scan came from a predecessor's server, whose original folder structure was gone. Laura offered to cancel the fines if I removed the stallions, stopped breeding in East Meadow, and recorded a permanent animal-free covenant there. She called that balanced." I asked whether Mesa Crest Resorts had approved the wording. Laura's hands separated. It was a small movement, but it was the first visible break in her control. Her attorney called the developer discussion unrelated. Martin slid the term sheet across the table, with its animal-free condition highlighted. I made a counterproposal. I would allow independent sound measurements, reinforce the visual barrier with trees, limit outdoor exercise before sunrise, and formalize emergency communication with the subdivision. I would not sell the stallions or burden East Meadow with a covenant, while ownership restrictions remained unproved. Laura returned the page. "The board cannot accept partial measures where resident safety is involved," she said. The conference ended without agreement. Before leaving, the HOA attorney gave Martin a written notice of a special board meeting. The board intended to adopt a revised fine schedule, ratify the existing charges, authorize collection by recorded vote, and direct a successor declarant filing under the 2001 assignment. Martin read the notice twice. "They are trying to fill the gaps while we are looking at them," he said. "Can they? They can vote. Whether the vote reaches your land is the dispute." The special meeting was held 6 days later. I attended with Martin. The clubhouse was nearly full, but the audience was quieter than it had been at my private hearing. Homeowners had received a summary stating that 8 dangerous breeding animals threatened community safety and a critical secondary exit project. Laura allowed Martin 3 minutes to speak. Martin objected to jurisdiction, the daily and pre-vote fines, the earlier collection referral without a recorded majority vote, and any attempt to revive an expired development right by board action. He submitted the county findings, title index, 2001 assignment, road agreement, survey overlay, and term sheet. Laura said the board had reviewed council's advice. She called for 4 motions. The first adopted a revised equine fine schedule, allowing charges every other day prospectively. The second purported to ratify all daily assessments already issued. The third, by a recorded 3-to-1 vote, referred my disputed balance for collection and authorized lien remedies. The fourth authorized Laura, acting for Juniper Ridge in its claimed capacity as successor declarant under the 2001 assignment, to execute and record a supplemental declaration adding East Meadow Parcel 7B under Ruth's 1999 consent. One director asked whether the lender release had been located and whether the 2002 deadline had expired. Laura answered that council considered both objections overcome by decades of reliance. Another director asked to delay the recording until the archived bank file arrived. Laura said delay would reward non-compliance. All 4 motions passed by the same 3-to-1 division. Martin placed one final objection in the record. A vote taken that night might authorize a future referral, he said, but it could not travel backward in time and legalize the collection firm's earlier involvement, nor could the board give its successor declarant role more time or fewer conditions than the developer had assigned. The vote could not correct the documents. It changed what the HOA was willing to do with them. 2 mornings later, on June 10, 2025, my ranch lender called. That morning's county stamp showed a supplemental declaration recorded against High Mesa, followed by a lien for $187,500. The ledger ran from March 27 through June 9 inclusive, exactly 75 daily entries, multiplied by 2,500, including the charges the board had just declined to use prospectively. The lender was reviewing whether the cloud on title affected the ranch's operating credit renewal. The lien transferred no ownership and authorized nobody to touch the horses. It simply placed a public claim beside my deed, where lenders, insurers, and future business partners could see it. Laura sent Martin a copy before the county notification reached us. Her cover email said the association remained willing to release the lien upon documented sale of the stallions. For the first time, waiting carried a cost I could not measure only in future legal fees. Breeding season was moving, feed, payroll, and veterinary expenses continued. If the credit review froze ordinary ranch operations, the animals would feel a paper dispute through delayed work and reduced choices. Martin prepared a civil complaint seeking a declaration of rights, release of the lien, and temporary injunctive relief. The motion asked the court to stop enforcement on 4 independent grounds: the disputed annexation, the unlawful daily fine sequence, the missing post-cure inspection, and the collection referral made before any recorded majority vote. He offered no guarantee that the judge would grant it. We still needed to defeat the most credible document Laura possessed: Ruth's real signature on a consent that appeared to include Parcel 7B. I took the recorded supplemental declaration back to High Mesa and placed it beside the copy from the first gate notice. Its signature block named Juniper Ridge as successor declarant under the 2001 assignment. That answered who claimed authority to sign, while leaving the survival of any annexation right unresolved. The pages looked identical until I compared the footer lines. The new filing identified Exhibit C as a 1999 attachment. Gabriel's report still carried his unresolved question about the survey control point. I opened the county index again. Then I wrote 2 dates on a blank sheet, 1999 and 2003. The second date came from a boundary line adjustment entry I had skimmed weeks earlier. I had assumed it concerned only a pasture division after the subdivision was built. Its description included the words East Meadow. Rather than guess what that meant, I called Gabriel and asked him to retrieve the complete 2003 survey before morning. Gabriel arrived before sunrise with a certified copy and 2 cardboard map tubes. The 2003 boundary line adjustment did more than divide pasture. It created Parcel 7B from land previously described only as part of the larger Hale Ranch. The survey established a new control point, new bearings, and the exact legal description printed on the HOA's exhibit. C. Gabriel laid the 1999 subdivision plat beneath the later survey. The older page lacked Parcel 7B because no separate legal parcel by that name existed yet. Its creation also came after the December 2002 deadline that the 2001 assignment expressly left unchanged. Ruth's signature remained genuine. The new fact changed what could honestly be attached to it. A document signed in 1999 could not have included a description first created in 2003. Someone might later update an exhibit for convenience, but the combined scan could not be the complete original Laura had repeatedly claimed. Martin asked Gabriel to prepare an overlay showing only dates, recorded lines, and control points. He also sent a preservation notice to the HOA and management company, demanding the native scan history and every transmittal involving Exhibit C. The bank archive arrived the next afternoon. The file contained Ruth's conditional consent, a cover inventory, loan correspondence, and the lender's decision. A red stamp crossed the consent. Release declined. The cover inventory listed a signature page and 2-page conditions, with no exhibit. C. A bank letter explained that annexing ranch collateral could weaken agricultural use protections and therefore would not be approved. The consent had remained in the file as an uncompleted proposal. The assignment gave Juniper Ridge the developer's place in that process, but there had been no completed process to inherit. Martin called Thomas Bell with the archive open before him. Thomas agreed to meet after seeing the records rather than hearing our description. He examined the stamp, the paper sequence, and his initials on the inventory. Thomas claimed no perfect memory. He said the documents reflected the bank's ordinary procedure and his work at that time. Then, he produced old Juniper Ridge treasurer minutes he had retained with permission when the board changed management companies. One entry recorded that the lender had refused release and that annexation would not proceed. Thomas looked tired when he signed a declaration authenticating his role. I should have objected when those files disappeared from later board packets, he said. He had left the board years before Laura became president, but he believed the failure was partly his. I told him I needed accurate facts, not an apology. His declaration alone could not decide the case. It connected the bank record to the association's own knowledge and gave Martin independent corroboration that the failed condition had been understood on both sides. Our lawsuit was filed with a motion for temporary relief because the lien was affecting active ranch credit. The court set a June 16 hearing and allowed narrow, expedited document exchange. The management company's export contained an email from Laura sent shortly before the first gate notice. She instructed staff to attach the current East Meadow description to Ruth's consent so the board would have one complete enforcement copy. The manager asked whether the updated page needed a new signature. Laura replied that the old signature already supplied authority. The email showed no forgery of Ruth's name. It showed Laura knowingly combining documents from different years and presenting the result as one original annexation package. That distinction mattered. Martin avoided theatrical accusations and added the authenticated email to the motion, asking the court to stop enforcement based on a record assembled after signature and after the required lender release had failed. The hearing room was small and cool. Martin brought the bank file, Gabriel's overlay certified county records, and the management export. Laura sat beside the HOA attorney with her red compliance binder closed. The attorney argued that an updated parcel description left Ruth's consent intact. He said the ranch had actual notice, received road benefits, and waited too long to object. He also argued that suspending enforcement would leave residents exposed to stallion risk while the case continued. Martin separated land authority from enforcement. The road payments arose from an agreement that preserved High Mesa as separate property. The 2001 assignment transferred only the developer's remaining right, leaving Ruth's lender condition and the 2002 deadline intact. The bank archive showed that release had been declined, while the HOA's new filing used a parcel description created in 2003. Gabriel's overlay placed each recorded line on its proper date. Even if High Mesa had been bound, the enforcement sequence still failed. The board imposed daily fines without the required post-cure inspection, and management referred the account before a recorded majority vote. The later 3-to-1 motion could govern future action. It could not repair the earlier referral. The HOA attorney challenged Gabriel's work as interpretation. Gabriel offered no ownership opinion. He identified only dates, monuments, and descriptions. Thomas limited his testimony to banking procedure and the minutes. When counsel questioned his old board copy, Martin produced matching agenda and page numbers from the management archive. The lender decision had been known at the time. Laura testified that the updated description merely clarified land Ruth had always intended to annex. Martin asked what language extended the deadline or removed the lender condition. She cited counsel, asked why the safety schedule had circulated before the vote and run daily. She called it an urgent draft. Martin then displayed her instruction to create one complete enforcement copy. Laura shifted responsibility to management. The temporary hearing resolved no final claims. The judge found that I had shown a strong likelihood that the annexation conditions and deadline failed, that the assignment probably could not revive them, and that the assembled exhibit raised a serious authenticity question. She also found substantial questions about the daily fine sequence, the missing inspection, and the premature collection referral. With the lien causing immediate harm against disputed property, she enjoined further fines and lien enforcement, ordered the HOA to record notice that both claims were suspended, and prohibited any entry onto High Mesa or interference with the horses while the case proceeded. Laura remained in place for the moment, but the order stopped the machinery she had been using. The next morning, the county clerk and recorder's index showed the court-ordered notice suspending enforcement of both the declaration and lien. My lender removed the hold from the operating credit review and confirmed that the ranch account would continue unchanged. A feed delivery that had been waiting for credit approval was released before noon. When the ranch manager read the order to the barn crew, nobody cheered. One handler simply asked which paddock needed work first. That return to ordinary decisions mattered more than a victory speech. The two mare owners received the county findings and the order. Both restored their bookings after speaking with the ranch manager, returning the season to its original schedule. I withheld Laura's email. They needed assurance that the horses would remain and that High Mesa could honor its contracts, not an invitation to become an audience for the lawsuit. The HOA's insurer entered negotiations after reviewing the management export and bank file. Over the next several weeks, the parties reached a written settlement. Juniper Ridge recorded releases of the supplemental declaration and the $187,500 lien, withdrew every fine, and corrected its owner ledger to show that High Mesa was not an association parcel. 2 business days later, the county clerk and recorder's index displayed both releases, and the title examiner confirmed that the disputed instruments no longer clouded the ranch deed. The insurer funded a $96,000 payment. The closing statement allocated it among legal fees, survey and title costs, and the 2 documented breeding contracts Laura's bulletin had disrupted. The separate road maintenance agreement remained in place because a valid agreement should not be destroyed merely because someone tried to stretch it. Juniper Ridge homeowners called a properly noticed member meeting. The debate was uncomfortable and divided. Some residents still wanted a secondary exit. Others objected to using their association to pressure land beyond the board's control. The members voted to recall Laura as a director. Before the remaining board could elect new officers, she submitted her resignation. The directors chose a new president the following evening. There was no public spectacle. Laura's final letter said she had acted for safety and property values while omitting Parcel 7B. The new board suspended the developer term sheet, required a current title opinion before enforcing against disputed land, and accepted the sound and emergency communication measures I had offered. Gabriel marked the East Meadow line with survey posts. The association promised not to cross it without permission and mailed each household a correction, stating that High Mesa was outside its declaration and had passed the county inspection. By late summer, I removed the steel screws, filled the holes and saved the weathered notice with the surveys, bank inventory, veterinary report, and court order. It was not a trophy. A complete record should hold the first false claim beside the final correction. Feed deliveries resumed through the shared road, and each side paid its written portion without pretending maintenance created ownership. On the first cool morning of the new breeding schedule, I led Orion into the training oval. He looked toward East Meadow and stepped through without pressure. Juniper Ridge stood beyond the cottonwoods, close enough to require good neighbor practices and far enough to have no claim on the lead rope in my hand. There was no celebration, only a healthy horse doing familiar work on land whose records finally matched its fences. Ruth used to say that a horse tells you when force has replaced judgment. Land records do something similar. They do not become clearer because one person speaks with confidence or repeats the word safety. They become clearer when dates, signatures, conditions, and recorded lines are placed in the right order. The HOA had real authority over its own lots and a valid road agreement with the ranch. I preserved High Mesa by identifying where those rights ended, accepting Ruth's signature and every inconvenient fact before challenging the story assembled around them. I had not outshouted Laura or found one magical page. Ordinary records formed a sequence that could survive resistance. The stallion stayed because patience gave the evidence time to meet itself. If someone tried to turn a paper claim into control over your property, what would you document first?